Welcome to the CCN Mexico Report podcast, an overview of Mexican legal, business, and political developments presented by the international law firm of Cascio, Cavazos & Newton. The content presented is for information and educational purposes only and should not be understood as legal advice.
Welcome to the CCN Mexico Report podcast. I'm Rob Barnett. In 300 palabras, Dr. Mario Melgar Adalid writes of U.S. Ambassador Ken Salazar's practice of visiting various Mexican states. Relations between Mexico and the United States are officially handled between the Mexican Department of Foreign Affairs and the U.S. Department of State. However, many other forms of exchange between the parties exist. Former U.S. Senator Ken Salazar, now the United States Ambassador to Mexico, has committed part of his time to visiting various Mexican states, which has generally served to broaden the country's relations. He recently traveled to the state of Aguascalientes, where he stated that, quote, cooperation with the government, the public and private sector in Aguascalientes has been beneficial for families living in the state. So in conjunction with the USMCA, people will continue to benefit from its potential for jobs, welfare, and more prosperity, end quote. The background for this activity is the bicentennial framework and joint declaration celebrated between the two countries, commemorating 200 years of diplomatic relations. Under this framework, the two countries committed themselves to investing in public health in connection with the impact of narcotics use, supporting safe communities, reducing homicides and high-impact crime, preventing cross-border crime by securing travel and trade, reducing arms trafficking, and reducing human trafficking. They also committed to acting against criminal networks by intercepting illegal activities and financing, strengthening the security and justice sectors, and related topics. In his visit to Aguascalientes, Ambassador Salazar recognized the good security conditions in the state, referred to its, quote, good people, and endorsed the interest of the U.S. government in continuing to promote teaching English and educational exchanges to the youth of Aguascalientes so that they may, quote, achieve their dreams and build their future, end quote. This visit is a good way to strengthen the ties that unite the two countries. In Political Thermometer, Dr. Mario Melgar Adalid writes that in the coming year of 2023, before the Mexican presidential elections occur in 2024, gubernatorial elections in the state of Mexico will be held, which will be an indicator of what could happen at the end of the current presidential administration. The importance of the election in the state of Mexico has multiple reasons. It is the most densely populated state in Mexico, which from a political point of view means votes. In 2020, with 17 million people living in the state, it is the largest state in Mexico. Additionally, the state of Mexico has significant economic and industrial development and is home to highly populated cities. It has been a bastion of the Institutional Revolutionary Party, or PRI, that is currently governing the state. Morena, the party of the current federal administration, has decided to reveal its candidate for governor with the purpose of starting pre-campaign events that will position her to win. The nomination went to Delfina Gomez, the former head of the Mexican Department of Public Education. She resigned from her post to run, which shows the importance of the nomination. It is not the first time Delfina Gomez has been a candidate, as 6 years ago she ran as a candidate for Morena and lost to the current pre-governor Alfredo del Mazo. The question is whether there will be an alliance of the opposition to face who would seem to be the candidate to beat from Morena. The National Action Party, PAN, has named its candidate as Enrique Vargas del Villar, mayor of Huixquilucan, an important municipality that borders Mexico City. This nomination, however, would not prevent a common candidacy from the PRI, PAN, PRD, and Citizen Movement, or MC, the current opposition parties. Both the decision to integrate a common candidacy and the result of the election will be of particular relevance for the already much-awaited presidential election to take place in 2024. The political thermometer will reach very high temperatures by then. CCN attorneys Jorge Ojeda and Mayra de Luna write that Mexico has published new rules for teleworking and health and safety rules in the workplace. On January 21, 2021, a new chapter was added to Mexico's federal labor law, or LFT, regarding the performance of work activities from a remote location away from the workplace, now referred to as teleworking. Although it is true that this type of work offers considerable benefits, it also generates new challenges for employers because it increases the locations where their employees carry out their job duties and their obligations for care, safety, and health of employees. The amendment of the LFT created new obligations for employers in connection with remote or teleworking, which will be established by the implementation of a new official Mexican standard, or NOM, for its acronym in Spanish. On July 15th of 2022, the draft of official Mexican norm NOM 37 on remote working, safety and health conditions at work was published in the official journal of the Federation. From a review of the draft, it should be noted that, if approved, the new NOM will apply only to employees working more than 40% of their shifts in the remote work form. It also establishes that employers, with prior authorization from their employees, must inspect the place where the remote work will be carried out in order to verify health and safety conditions and to confirm an adequate workspace exists. The process of creating a NOM begins with its inclusion in Mexico's annual National Quality Infrastructure Program published by the Department of the Economy. Then, following subsequent stages of proposal presentation, analysis, review, draft, assembly of working groups, deliberation, and publication of the draft NOM in the official journal of the Federation for comments, interested parties can then make comments within the following 60 days before the NOM is finalized. Once the comment period has concluded, comments are considered in the assembled working groups, and it is important to keep track of the development of proposals and final terms for this NOM 37 so that employers may properly implement new rules. CCN attorneys Jose Maria Lujambio, Antonio Riojas, and Maria Elena Hernandez write that Mexico's Department of Energy, or SENER, seeks to limit competition in the natural gas market. On June 13th, Mexico's Department of Energy, or SENER, issued an official communication instructing the National Center for Natural Gas Control, SENEGAS, as part of the requirements to transport natural gas from importation points where a state-owned company or its subsidiaries has reserved capacity at such importation points. New requirements will now exist. The new mandates state that shippers or those interested in receiving natural gas transportation service must prove within 60 days that they receive their supply from a state-owned enterprise, or EPE. In the points where an EPE has reserved capacity, the EPE contract will prevail. Provision of transportation services in any form within the system operated by SENEGAS, or Sistrangas by its Spanish acronym, is ensured by contracting upstream transportation capacity from an EPE, or state-owned enterprise. Authorizations or request of transportation service are conditioned on the fulfillment of these prior points. Additionally, in its official communication, SENER called on the Energy Regulatory Commission, or CRE, to modify the terms and conditions for providing services within Sistrangas in order to include these new rules. In other words, SENER intends for Sistrangas' shippers to purchase natural gas from the Federal Electricity Commission, or CFE, or Petróleos Mexicanos, Pemex, or at least acquire the transportation capacity from them in U.S. territory. This is insufficiently grounded on SENER's authority to establish, conduct, and coordinate Mexico's energy policy. Thus, under the argument of using the EPE's idle capacity in Sistrangas, SENER seeks to impose the EPE, and especially CFE, as marketers, which would violate the constitutional principle of free economic competition and concurrence. This is called for instead of making available to any interested party the idle capacity of the EPE through an open season in accordance with current legislation. Mexico's Federal Economic Commission, COFECE, has warned that this strategy seriously and irreparably damages the conditions of competition in the natural gas market and also in the electricity market, since it prevents equal access to the capacity of Cistrangas to shippers who would not want to contract with state-owned companies. The strategy limits the entry of new natural gas marketers, preventing them from contracting with the most efficient suppliers by adding a mandatory intermediation that could raise prices for this fuel. Meanwhile, Senegas has already notified certain transportation shippers via an official communication, requiring them to comply with SENER's strategy and to submit information showing that they have contracts with CFE or Pemex. In turn, Pemex issued a letter informing shippers of its available capacity to facilitate compliance with Senegas requirements. As announced recently, the U.S. Trade Representative has decided to include the actions of SENER and Senegas as part of the 4 items of Mexico's energy policy recently submitted for consultations in accordance with the dispute resolution provisions of the USMCA. As of today, some affected companies have filed amparo lawsuits against SENER's strategy and its initial implementation by Senegas. It has been made public that the first district judge specialized in economic competition has granted at least one definitive injunction against the acts claimed in favor of 10 companies, which means that the new requirements would not be enforceable against these 10 companies until their lawsuits have concluded. It is possible that the lawsuits initiated by these 10 companies, and especially the consultations initiated by 2 of the USMCA's parties, may exert some pressure on the Mexican federal administration to rethink an energy policy that has repeatedly proven in court to be contrary to currently applicable law. CCN attorneys Eduardo Parroquin and Abigail Maya write that Mexico's Supreme Court has issued an important new decision on the scope of powers of attorney. Under Mexican law, the delegation of authority to a third party, whether by a company or an individual, must follow a formal procedure involving the execution of a written power of attorney, which in most cases consists of an instrument establishing the specific authority that the attorney in fact will have. The granting of powers and legal authority takes on special importance in the case of companies, considering that the only way such entities can operate is through representation by individuals, who acquire sufficient authority as legal representatives or attorneys in fact to carry out those acts the company requires them to fulfill its purposes. The powers that may be granted to an attorney in fact can be general, limited, or special, depending on the actions that the attorney in fact will carry out. The provisions of Article 2554 of Mexico's Federal Civil Code state that the powers of attorney can be listed as follows. 1. Lawsuits and collections, which are important in the context of litigation or disputes in any matter. 2. Acts of administration, which are essential for the operation of a company and allow for the execution of contracts and the execution of actions intended to preserve the assets of a company. And 3. Acts of ownership, which allow the sale or disposition of a company's assets. The general powers contained in the Mexican Federal Civil Code have been the subject of analysis by Mexican courts on multiple occasions. In one of the most recent cases, the Mexican Supreme Court of Justice resolved in 2018, in case decision 225-2016, that a power of attorney for acts of administration is different from the power of attorney for lawsuits and collections, and that each one has its own nature and purpose. This means that a power of attorney for acts of ownership does not contain implicit powers to administer, and likewise, that a power of attorney for acts of administration does not contain implicit powers for lawsuits and collections, as had been interpreted prior to the Supreme Court's decision. This new Supreme Court decision is important for companies, since those powers that they grant to their attorneys in fact must be in accordance with the actions that each attorney in fact performs. This will avoid situations in which the actions carried out by the attorney in fact could be disputed, Thus, it is always recommended that companies determine the precise authority to be granted to attorneys in fact, according to each case and specific situation.
Thank you for joining us for this edition of the CCN Mexico Report podcast. Subscribe to the CCN Mexico Report newsletter at www.ccn-law.com to receive the full text of this edition's articles. This podcast is copyrighted 2022 by Cascio Cavazos & Newton, LLP. All rights reserved.